Good afternoon. It's officially the afternoon, 12:01. Hi, I am Michael Liptrot, and I will be conducting the webinar today. Thanks, Taylor. Thanks, everyone, for joining. And we can just head on to the next screen, Taylor. So first, a little bit about me. There's me, my little picture. I am here with Tully Rinckey in the Family Matrimonial Department. I do some other areas of law, but the bulk of my practice has been, for the past nearly 10 years, litigating in divorce, custody, child support, all those family matrimonial issues. Certainly a lot of modifications, which is what we're going to be diving into today. Um, I am certified. I took a course, got certified in divorce mediation. Um, I think, alternative dispute resolution can be a useful tool for some parties. You have to have the right attitude. You have to have the right set of circumstances. Certainly, it's not for everyone, but it can definitely be beneficial for some. And a little bit about my philosophy, my approach as an attorney. Um, I think that each family is certainly unique, specific set of circumstances and facts with each case. You want to get to know the parties, um, your individual client, their needs, their desires, their goals, and especially in the case of custody, you have parents, children involved. It's a fact-intensive approach. So definitely tailoring the situation to fit each family is highly important. And often the disputes are resolved by agreement rather than trial. Sometimes a trial is necessary. You leave it in the hands of the judge, but it can be better for the parties to reach their own, determine their own faith, so to speak, about how they're going to arrange their parenting time. So you definitely want to focus on the specific facts there. All right, we can head to the next slide, Taylor. Okay, so today we're going to handle the what, when, why, and how of family court modifications. Specific topics we're going to cover. What is a modification? That might seem obvious, but there are some caveats there as far as what the family court can and can't do. It depends on if you are coming from a post-divorce judgment or did you get your initial order in family court. Why you might go to the family court instead of the Supreme Court. Family court is limited jurisdiction, so there's some benefits and limitations there, but we'll talk about why you might go to family court primarily. How do you get your modification heard in family court? What specifically do you need to do to get in front of the judge or magistrate in family court? We'll talk about that. And when and on what basis will the family court grant a modification? What is by statute enables a modification? And what do you need to set forth in your pleadings to get modification granted? We'll talk about the big cases. There's a couple big cases, the seminal case law there, defining what is quote unquote substantial change in circumstances and quote unquote the best interest analysis. And we'll look at some recent trends as far as factors the courts recently are looking at and are considering when granting modifications. Okay, Taylor, we can go next. So, what is a modification? Modifications are, simply put, changes to the existing court order or stipulation. You started out in Supreme Court if you're getting divorced, and you ended up with a judgment of divorce. Maybe you made an agreement as far as all the issues pertaining to your divorce, and that was incorporated in the judgment of divorce. That would have happened in Supreme Court. Or if your parents are unmarried or you just dealt with the issues of custody and child support and remain married, you would have gone to family court for that initial order. And you have to head back to family court to modify that existing order. The only way to modify your existing order or stipulation would be to obtain a subsequent court order, or if you executed a stipulation with the same degree of formality as the original, you could modify it that way. You would probably get attorneys involved to make sure you do that correctly. But you cannot just have a verbal agreement or um, conduct yourself, circumstances change and you're getting along with the other parent and you agree to a certain arrangement that is deviating from your order. Uh, just that alone is not a modification that's going to be upheld. Should the other parent stop cooperating, right? You're going to look back to the original order unless you have subsequent court order modifying. And specifically with the family court, they obviously could modify their own orders, but they can also modify the judgment of divorce. The family court is empowered to have concurrent jurisdiction with the Supreme Court as far as the issues of custody, visitation, and support. The Family Court derives its authority from the Family Court Act. The Family Court Act establishes the family courts and imbues it with the authority to take action in the specific articles enumerated in the Act. With respect to modifications, custody and visitation is pursuant to Article 6 of the Family Court Act, and support is Article 4. The family court does also have the authority to modify spousal maintenance, but that there's a high bar as far as modifying maintenance, and it's almost always for a temporary limited period in duration. Spousal maintenance is rarely modified. People rarely go for a modification on that issue. So it's usually custody, visitation, and child support if you're looking for a modification. All right, Taylor, we can go to the next slide. Okay, so why would you go to family court instead of the Supreme Court? As I mentioned, the family court is a court of limited jurisdiction. Its powers are limited to what's enumerated in the Family Court Act. As a court of limited jurisdiction, it's sort of set up to be more, I guess, efficient or focused in its scope than the Supreme Court. The Supreme Court in New York, as we know, is the trial court level. They're handling all sorts of issues. Wide-ranging. So the family court is designed specifically to address these family law issues, and that can be a benefit. You have the justices and magistrates familiar specifically with that area of law, and there's a particular way of conducting business in the family court. So there's some cost and efficiency savings there going to family court. Proceedings are generally going to cost less because, well, there's fewer filing fees. There's no filing fee to file your pleadings in family court, and the family court will often appoint the attorney for the child, which most often parties won't have to pay for. You also have a right to counsel in custody cases, and depending on your financial circumstances, you could have an attorney appointed for you if that's necessary. But the attorney for the child is usually no cost to the parties. Okay, we can go to the next slide, Taylor. Okay, so we now know what a modification is, and we've decided to go to family court. How are we going to do it? If you're looking to modify in the family court, you file a petition. This is different than the Supreme Court where you would file a summons and complaint. It's also different in that you file a petition in family court to for an initial order of support or custody, and it's the same mechanism. You file a petition for modification in the family court. In Supreme Court, you'd file a summons and complaint to commence the action. If you're filing, you're the plaintiff, the other party is the defendant, and the defendant in response would serve, cross motion, an answer, and then, counterclaims. And for post-judgment relief in Supreme Court, you would be filing motions post-judgment. And if you were the defendant in the original proceedings, you would remain the defendant. The plaintiff would remain the plaintiff. In family court, if you are filing the petition, whether it's to initiate or on a modification, you are the petitioner if you're filing the petition. So it can get a little confusing in the case of both parents filing petitions, cross petitions for modification, then they both become petitioners and respondents in the same proceeding, and each one would have their own docket number, whereas in Supreme Court it's just one index number, and one party is the plaintiff, one's the defendant. In family court, custody and visitation petitions are heard by a judge or court attorney referee, while the support petitions are heard by a support magistrate. Rarely does the family court combine custody and visitation proceedings with support proceedings. This also means that if you're looking to modify custody and child support, you would be filing two modification petitions, and you would be proceeding in two sort of courtrooms within the family court as things progress. Okay, and I just wanted to show you all what these modification petitions look like. So if Taylor, we could head over to the custody modification petition PDF. And this is the New York State form for modification petition. I just want you to see sort of what it looks like. It's the first page is basic information, and then Taylor, if we can scroll down. So here you're going to list your basic information and then the prior order, and you are definitely going to want to attach the original order so that the court knows what you're seeking to modify. Even if the prior order is a family court order, you'll need to include that in your pleadings. And if we could just go up one more, I think page 3, Taylor. Right, so you can see there, sorry, numbers 8 and 9. That's where you're really going to fill out, and you probably, if you're using an attorney, you're definitely going to use a different sheet of paper. If you're doing it on your own, you're going to want to attach additional information, because that's where you're going to go fact intensive there. You need to show that there's been a change of circumstances, and as we're about to talk about, it's a substantial change of circumstances from the date of that original order. And due to the change of circumstances, you're going to be talking about that it is in the best interest of the child or children to modify the order as you know you are suggesting. Okay, so that's good, Taylor. And then if we could just hop over to the support modification petition. Yeah, we just click that support modification. Yep. And this, like I said, if you're looking to modify custody and support, you're going to be filing two petitions, and this is the other form that you would base your petition off of. You'd make sure to include the original order, and I think maybe it's page 2, Taylor. Oh, no, all right. So yeah, so paragraph 6 here. There's really 3 main ways you can modify child support. One is the same substantial change in circumstances, and then if we scroll down to page 6, the next page. And then the other 2 ways, 3 years have passed since the date of the last order, or a 15% change in income of either party, up or down. And so that's what that form looks like, and those are the three bases. And we can go to the next slide. Okay, and so that's how you modify it. And when should you modify it? When is the court really going to grant a modification petition, or what are you going to allege? When is it time? Um, in cases of custody, visitation, and child support, it's this standard of a substantial change in circumstances, and the substantial change in circumstances is from the date of that original order. Um, you have to allege that something's changed since that order. It can't be um, conditions that existed at the time, but now have made it inconvenient for you, or you can't, still hold a gripe and try to get a second bite at the apple, so to speak, by modifying based on something that existed at the time of the order. And in the case of custody and visitation modifications, um, that change in circumstances is not enough. You have to prove that it's things have changed, and what you're asking to do based on that change is in the best interest of the child, not in uh, necessarily your best interests. Um, if things have changed, for example, you have relocated and now you are closer to where the children live, and you want to increase your visitation if you're the non-custodial parent, you're able to exercise overnights during the week, or um, you can pick up and drop off the kids from school, so you want more time. Um, that might be a change from the original order, and it might even be a substantial change if it's really a significant difference. But you also have to be able to explain to the court why what you're asking to do is going to be a benefit to the kids and not just to your own benefit. That's with respect to custody and visitation, that best interest analysis. And with respect to child support, we talked about it a little bit, but the Domestic Relations Law, DRL 236B 9B, is the statute which for orders that are entered after, it's only applicable to orders entered after October 2010. These three bases apply, and you can see the court may modify upon a substantial change in circumstances, as we talked about, um, and where, these are the two new ones, 3 years have passed since the order was entered, last modified or adjusted, and there's been a change in either party's gross income by 15% or more. That's 15% up or down. So those two additional factors will get you into court. You have the right to go to court to have your child support reviewed upon those circumstances. Whether or not your modification petition gets granted is another story. This just would prevent your petition really from being dismissed as not alleging a sufficient change. If 3 years have passed since the order was entered, you can come to court and you can require the other parent to exchange financial information, produce it to the court, and disclose it to you. And it could, come to pass that despite 3 years having elapsed, your incomes are substantially similar, and there's really no need, or it would not be appropriate to modify the child support in any way. But at least these will automatically get you into court for that review. And then one important note for people who maybe experienced a job loss or reduced income, maybe even so significant that it's 15% change. You, if you come to court, you better be ready to show some proof that your lower income was due to no fault of your own. It was an involuntary reduction in income, and that you've made diligent attempts to secure employment commensurate with your education, ability, and experience. Frequently, the support magistrates will look at your prior earnings, and that you'll be deemed to have a certain level earning capacity. And if you are not meeting your earning capacity as evidenced by your prior income levels, you're going to have to be able to explain why. It can't be right that you started your own business and you voluntarily left your six-figure job to pursue your dreams, right? Running a restaurant, and things just aren't going the way you had hoped. Um, that's not going to be enough. Uh, they're going to want, even if in the case of unemployment, um, you'll have to have a layoff letter just saying, that was no fault of your own from your previous employer, and a job log where you've been looking for work and your interviews and such. One final note about child support modifications. Some people get hung up on this. Modifications of child support are effective as of the date of application for the modification. So some people come to court and they file, and then we get to court, and it's well, I want my child support reduced to the date I lost my job, 6, 12, 18 months ago, and you filed your petition 1 month ago. And the court is only going to grant you that relief as of the date that you file that application. They're not going to reduce your child support obligation for that period of time, even though it may be true and it may be no fault of your own, and you may have engaged in best efforts. Um, and some people, they're going through a lot. If they're experiencing job loss in that situation, you might be struggling to find a new job, and you're balancing how to pay your bills, and also you have this child support obligation, and maybe you're working with the other parent. If you're in the case of direct pay, maybe the other parent's being very friendly and is saying, well, don't worry about it this month, or we'll take less and we'll figure it out until you get back on your feet. But that entire time until you file that petition for modification, um, you are being assessed with the full amount of your child support obligation, and arrears will be accruing to the extent you fail to make that child support payment. I think that's all. We can go to the next slide, Taylor. Thanks. Okay, so here's the big case law in the case of if you're filing a custody petition, modification petition, you're making legal arguments, uh, or if you're reading legal arguments, you are probably seeing reference to these two cases, Friederwitzer and Eschbach. These are the seminal cases. You can see Court of Appeals 1982 um, regarding custody modifications. Both cases involved modifications of prior agreements, not court orders. They were post-matrimonial. Um, and there, the court noted that priority will be given to agreements. It's great that we give people the ability to contract, and generally contracts are fully enforceable, and we want to um, make that it's an important thing to maintain. But in the case of custody and visitation, if circumstances change and the best interests of the children require it, those agreements can be modifiable, either by subsequent agreement or court order. And as noted before, the analysis is going to be the best interest of the child or children. That is the ultimate consideration. And in these cases, these two important cases, they noted the following factors: quality of the home environment, parental guidance each parent provides, the party's financial status, um, ability of each parent to provide for the child's emotional and intellectual development, and the desires of the child, but factoring in the child's age and maturity and the potential influence of either parent on the child's desires. So those are noted in those cases there. And just a fun fact about Friederwitzer, some attorneys might know this, family law attorneys in New York City definitely. Brooklyn Family Court Justice Lisa Friederwitzer, she was the subject child in the Friederwitzer case. So she's certainly had full family court experience there with custody and custody modifications, and now she's a family court judge deciding other people's custody modifications. So it's pretty interesting. I've been before her a few times. She's an interesting person. All right, Taylor, we can go to the next slide. So Friederwitzer and Eschbach gave us, sort of maybe abstract factors, but I was just listing here some real world examples of what people might experience after they enter their initial agreement, divorce agreement or custody agreement, child support agreement, or court order. Parties move on, they get remarried, and either or both parent could be finding a new spouse or cohabiting with someone else. And, in the case of the custodial parent, uh, if they're getting remarried, that means the child now has a step parent who also lives in their home. And, that can certainly create a situation where the non-custodial parent might have feelings about what the custodial arrangement should be and what the best interest of the child is. And that again, that's going back to where there may be a substantial change in circumstances, but you are also going to have to show the court why it would be in the best interest of the child to change the current order. Parents could be getting a new job, increased income, increased resources, and then maybe, tying into the next point, they could be moving to a new, better school district, or, relocating closer to the kids, as I mentioned, have that ability. Uh, so a new job could serve as a basis for modification. Relocation I put there, uh, that's almost automatically going to be uh, a basis for heading back to court, especially in the case of the custodial parent, where you are looking to relocate. If you're going any significant distance from your current home, you would be changing the parenting time abilities of the other parent. And if the non-custodial parent's parenting time is disrupted by this relocation, and that they're being deprived of time, or even if they are having to increase the burden of exercising their time, that you're going to need a court order or the agreement of that non-custodial parent to do that relocation. And so a relocation is going to almost always require some sort of modification, whether it be by court order or written agreement. Then maybe obviously, so if there's sudden, deterioration, mental health of either party, if they experience a crisis or episode, that can trigger analysis there about the custodial arrangement. If either party is experiencing issues with substance abuse, or if a party becomes incarcerated, that's going to certainly affect their parenting time if they're the non-custodial parent. And if they are the custodial parent, that's you're gonna have an almost automatic change in custody in the case of incarceration. But again, with the mental health issues and substance abuse, you're going to have to show that the circumstances are changed really from the current order, and that it would be in the best interest of the children to modify the arrangement. It can't just be just some blanket allegation. Well, the custodial parent has these issues, so I want to litigate. You have to show that something specific is happening, something is changing, that's requiring a modification. I put maybe exclamation point there, tweens, teens. Kids are always getting older, and That's a fact of life. And if you entered into your order when they were younger, maybe you had a 4, 5, 6-year-old at the time of your current order, your original order. They grow up, they're hitting puberty, um, they're developing. You might have one parent who is more equipped or just better able to relate to or handle that specific child. And it could be the custodial parent, just there's no reason for a change, but they're certainly the court will look at developing children's development as a change of circumstances. If uh, the non-custodial parent has, demonstrated a better ability to take over the custodial duties with a developing child. And all these factors are interesting and applicable, but the court does, have a catch-all. Any other factor that might be appropriate in a particular case. So attorneys and litigants, you can get creative with your factors as far as what's changed and how you think the best interest of the children can be served by particular modification. But with that being said, you have to be realistic. So I do have, on the one hand, I've seen recently just a few cases. I don't know why, and it's small, right? So uh, you have one parent wants to go on vacation with the kids, and that vacation is abroad, and so the kids need a passport. And what happens, the the other parent, even if you guys are getting along and now you want to take this vacation, and then the other parent, I don't know, sees something on Instagram that makes them upset, and now all of a sudden they are telling you, no, I'm not going to sign off because both parents need to consent to uh, the obtaining the passport. They either both have to be present for the application, or there's a consent form that one parent can sign, and they'll say, no, I'm not going to sign off. You don't get to go on your trip. Um, and so now you have a parent coming to you or running to court, and they are filing a modification petition um, to be given the authority to obtain this passport and to direct the other parent to cooperate. Um, and very often, unless there's some real reason to prevent it from happening, the court's going to grant that modification. So that's a small modification where you go back to the law and you think, okay, substantial change of circumstances, best interest of the child, these are weighty issues, but there's some small stuff and the courts will get involved. And then, on the flip of that, you have some parents who are deeply unhappy and with the arrangement, and every day is a struggle to deal with the other parent. But and it's just a lot of little things, and it builds over to a point in time where they just say, like, I need to ask the court for help. And you go back and you look at the history, and it's just not enough. It might not be fun to deal with a parent, the other parent. There were circumstances leading to the demise of your relationship, right? So you didn't get along, and you might continue to not get along, but unless there's a real need to modify the custodial arrangement, the courts are reluctant, I would say, to do so. They don't just want everyone coming to court over and over again. They expect you to work some of these issues out. So you have to be realistic in your approach to a modification. And sometimes it's just you have to be polite and get along, and there will be a moment with a significant event that's going to let you, get that hook to get to court. All right, Taylor, we can go to the next slide. Okay, and so here, I was just looking at some cases recently. The big trend that I've seen, one major factor that's not, specifically listed in our seminal cases, but is very important to the court and to the parties. We see it all the time. This phrase, parental alienation. Um, I think every parent who is unhappy with their parenting time is getting the feeling that maybe the other parent is engaging in parental alienation. And you get a lot of potential clients, current clients who do their own, the WebMD version of legal research, Googling here, what is parental alienation? They are reading the books and watching videos about it, and they are certain that that is true in their case. Um, and you can see here, I put a quote here for parental alienation, and it's important. Parental alienation of a child from the other parent, including willful interference with visitation, is an act so inconsistent with the best interests of the child as to per se raise a strong probability that the offending party is unfit to act as a custodial parent. So, if parental alienation is evident in a case, uh, per se, a lack of fitness to be the custodial parent. So it's a very important issue. But what I think the court is more looking at is this bullet above, willingness to foster a relationship between the child and non-custodial parent. So I have two cases here, Smith v. Francis in the second department just a few months ago. This came down, and Smith v. Francis was a case where um, the appellate division looked at the record of the family court trial, and they actually overturned the family court case, the family court decision there. The family court said that there was not enough evidence that the custodial parent was failing in his duties to act as the custodial parent. And the appellate division said, no, the evidence is so clear. We're not even going to remit back to the family court for trial. We are going to transfer custody based on what we see here. And what they saw was the father's efforts to undermine the relationship between the child and the non-custodial parent, who is the mother, and his active disparagement of the mother in front of the children, and his failure to involve the mother in the education and health um, of the child. So that was a big surprising case. Usually, you'll see if the appellate division isn't sure about the trial court's determination there, they'll say, "Look, here's what we think you went wrong. We're sending it back to you for take what we're saying, and try again, basically." But there, the appellate division just transferred custody based on the written record, and that is because here this fact, willingness to foster a relationship, um, is so deeply important. And I put there Williams v. Rolfe, also is a third department case, decided along similar lines in support of that fact. So yeah, the court, I think recently, they're looking to this. It's almost a duty of the custodial parent to ensure that the relationship between the child or children and the non-custodial parent is maintained and is supported. You can't be a fit custodial parent and just take a back seat there. You have to encourage the children to see and speak with the non-custodial parent and strengthen that relationship. And it can be trying sometimes, I think, with certain children expressing a reluctance, but that's where the court is at, and it's an important issue. So I think that's it. Taylor, we can go to the next slide. All right. So just recapping today, um, we talked about some good topics. Where and how to file a modification request. Obviously, the where is the family court, and it could be in the Supreme Court, but we talked about why you might want to do it in family court. It's more efficient, more cost efficient, more time efficient. You have judges there that are focused on the family law. How to successfully modify your pre-existing custody support agreement in family court. That's going to be by petition, and we took a look at those petitions, and you want to make sure that your pleadings are fully fleshed out as far as the substantial change in circumstances um, and the best interests. You want to convey that in your pleadings. The role of the family court in adjudicating issues post-judgment divorce, the family court is imbued with authority to modify Supreme Court decisions, the judgment of divorce, but only to the extent that those areas are under the Articles of the Family Court Act. So they're not dealing with the sort of financial, maybe equitable distribution, retirement assets, that kind of enforcement, post-judgment issues of divorce. That's going to remain with the Supreme Court. The essential components of a modification petition, we talked about substantial change circumstances for both support and custody, and then the best interest analysis in the case of custody, and either one of those three factors in a child support case. And then finally, we looked at the case law, right? We looked at the bedrock case law, Freedom Richard and Eschbach, and the current trends in the family court, where they're headed as far as stressing particular importance on custodial parents' duty, so to speak, to foster the relationship between the child and the non-custodial parent. And I think that's all I have. So maybe we can answer some questions. And yeah, so I'm actually just gonna look over here. Got a list of questions. Okay, one question is how to modify a pension that your spouse is receiving. A pension modification of the division of a pension is going to be a post-judgment divorce issue in Supreme Court. So like we said, the family court is limited jurisdiction. They're going to be dealing with the issues of custody, visitation, and support. But something like a pension, you are probably going to have to be filing a motion, either by notice of motion or order to show cause with the Supreme Court using that same index number that you had from the divorce action. You'll reopen that case to the extent possible. And if you were the defendant, like I said, you'd remain the defendant, filing that petition or order to show cause, rather. And that would happen in the Supreme Court. You might not get the same judge as your divorce case, but it would be in Supreme. Okay. Next question. Can the fact that the non-custodial parent takes the kids to school daily and picks them up multiple times a week from activities count as time? Or expected when they're with the custodial parent? So you would have to refer to your custody and parenting time arrangement that is in your existing order or the judgment of divorce, stipulation or order. And if you are the non-custodial parent and you have time with the children during the week, that and the kids have extracurricular activities during your time, there will be an expectation that you take them to those activities. And the custodial parent should not be scheduling extracurricular activities during the non-custodial parent's time, exclusively during the non-custodial parent's time, so as to deprive them of that time. If they did that, that could be a basis for, um, modifying the arrangement in some capacity where you, as the non-custodial parent, have additional authority to maybe have further input with respect to the activities that get scheduled, what the kids get enrolled in. But generally, if the activity is just like, it's every weekend, right? And it's going to infringe on the custodial parents' weekends with the kids as much as it interferes with the non-custodial parents' weekends. The court's going to look at that and say, you're both parents. This is what kids do. They do activities, and you are both equally expected to, make sure that they get there and attend those activities. So I hope that answers that question. Okay, so this one question, this is relating to relocation, and I hope this will answer the question, at least in New York, with respect to out-of-state relocation. The court has continuing exclusive jurisdiction so long as one of the parents uh, resides in New York. So even if the custodial parent and the child move out of state, if the non-custodial parent is in New York, then New York's going to retain exclusive continuing jurisdiction over that case. And to the extent that a petition is brought out of state, um, it could be transferred back to New York for determination. Okay, so another relocation question. With respect to relocation, how far does it have to be for change in child support or custody? Um, so the distance of a relocation is not going to impact your child support obligation, unless it is such a significant relocation that you could argue the costs of to exercise your parenting time are so significant that you would have to argue for a deviation from the support guidelines. It could serve as a basis. Um, it You'd have to really show, probably airfare would have to be involved, I think, in order for that to modify your child support downward. Um, and as far as distance for change in custody, so with relocation, it's tricky. Relocation cases are complicated. Um, the parent seeking to relocate has to show that the relocation is um, in the child's best interests. So that notwithstanding the detriment to the non-custodial parent's parenting time, you it's worth it for the kids. It's a significant upgrade in the school district, or you have the opportunity to make significantly more money. And it's going to increase the resources available to the children, and their housing accommodations will similarly be upgraded. It's going to significantly improve the standard of living for the children. Um, if you are looking to relocate, if you're the custodial parent and you're looking to relocate and you do not have these facts with you, and you just want to move a significant distance away, you are likely going to be facing a change in the custodial arrangement, where the other parent might be designated the custodial parent. So that's definitely something to consider when you're looking at relocating. think I'll take one more question. One says, how do fixed assets play into child support when deciding child support amount? So, in terms of fixed assets, um, they would have to be producing consistent, regular income to you for that to factor in. Um, the courts are generally looking at income when they're deciding child support. And if you have if you have an asset that's producing fixed income, or even, it's a stream of income that maybe it's sporadic, but at the end of the year, it's consistently generating some sort of return. The courts are going to look at that and include that as income to you. Child support is income from all sources. So, you know, fixed income, like a pension, or if you have some sort of bonds that generate steady returns, that's going to be income to you, in addition to your wages. And I think that's it, Taylor. I think we did it. All right, everyone. So thank you for joining. I appreciate everyone showing up. I hope it was informative. I had a good time, so I'm glad I was able to do this. Thank you.